If you have ever felt confused about the EB-5 sustainment period, stressed about your child's aging out, or frustrated by the endless I-526E and I-829 delays, then I want you to know you're not alone. Today's guest isn't just a legal expert in the EB-5 world. He's someone I have personally reached out to when things got complicated legally for my investors. Niral Patel, partner of KLDP LLP, who has represented investors in failed projects, taken on federal lawsuits, and worked with SEC to protect client interest. But more than that, he brings clarity when there is confusion and heart where there's stress.
Just so everyone knows, sustainment period really determines when you get your money back in EB5, right? I think everyone, when they go through EB5, they want to make sure their green card is protected and they're going to get their green card, but they also want to make sure that their investment is also going to come back. What if tomorrow they decided to post on their website, actually the investment amount is 1 million? As long as you're with the right team, with the right consultants, the right attorney, and the right project, and at least you have peace of mind that, okay, at least if my money is locked in for 5 years or 6 years, at least it's with the right people. So it's not a matter of if I'm going to get it back, it's just a matter of when. I think you have to understand the risks of age out. Because while the age is locked in when you file the I-526E, let's assume that it takes 12 months for that I-526E to be approved. So 12 months from now, when that I-526E is approved, the age will start to unlock. At that time, we have to see if visas are available. Now, as you know, demand for EB5 over the last couple of years has been high, and at some point we are looking at a backlog.
What exactly is writ of mandamus, and who is eligible for it?
So a mandamus is a lawsuit. It's a lawsuit that's filed in federal court. And so I do tell my clients that, look, if you're going to do this, you have to make peace with certain things. The number one thing I say is processing times. That's something, again, no one sitting in this room has any control over processing times. That's purely the US government. So again, this comes back to, as long as you pick the right team for you, that's securing your capital and securing your green card, then you're going to be fine. But you do have to exercise a lot of patience going through this process.
Hello everyone, welcome back to EB5 Decoded by Quantum Global. I'm Rashika, CEO of Quantum Global. This episode is very special to me. Not because of the topic, but because who I'm speaking with. If you have ever felt confused about the EB-5 sustainment period, stressed about your child's aging out, or frustrated by the endless I-526E and I-829 delays, then I want you to know you're not alone. And this conversation might help you. Today's guest isn't just a legal expert in the EB-5 world. He's someone I have personally reached out to when things got complicated legally for my investors. Joining me today is someone I have tremendous respect for, someone whose legal acumen echoes in every serious EB5 room. Niral Patel, partner of KLDP LLP, who has represented investors in failed projects, taken on federal lawsuits, and worked with SEC to protect client interest. But more than that, he brings clarity when there is confusion and heart where there's stress. Neeral, thank you so much for joining us today.
Thank you so much for having me. So happy to be here.
So before we dive in, I understand your practice is very crazy. You work across time zones for your investors and you're available at all times, which is something that I'm learning to acquire. So how do you manage your life? Like, what is it that one thing that sets you apart?
I think, as a firm, the number one thing I always tell my paralegals or I tell any client, that I work with is I'm a lawyer. We provide a service. And that's what we aim to do. Is our goal is to always provide the best in-class service to our clients. And I think the number one complaint that a lot of lawyers get is they're not responsive enough. So that's always been a priority to us, is to respond to our clients, be there for our clients. And with that does come some crazy work-life schedule. But I think, we're young enough. We have the energy. We have the energy to keep running. And so that's what we keep doing.
Yeah. So one thing that I really want to tell to all of our listeners also today is, Neeral is one person. Whenever I text, whenever I call, he's always there. Let it be any time zone. And thank you so much for that.
Yeah, I don't think my wife's too happy about that because I'm constantly on my phone.
Yeah.
But again, I think that's something that when I got into the legal practice, when I got into immigration, especially understanding, especially with what's going on in US immigration right now, you can understand the anxiety that a lot of clients have, that a lot of consultants have for their own clients. And I think it's important for us to prioritize those.
That's right. So before we get into the complete EB5 angle of it, let's address the elephant in the room. There's a lawsuit happening with respect to EB5 sustainment period. So what do you think about it?
Just so everyone knows, the sustainment period really determines when you get your money back in EB5, right? I think everyone when they go through EB5, they want to make sure their green card is protected and they're going to get their green card, but they also want to make sure that their investment is also going to come back. And so previously, and when I say previously, this is before March 2022, under the old iteration of EB5, your sustainment period was the 2-year conditional residency period that you had, which means that once you got your conditional green card, that was valid for 24 months. When you filed for the 829, that's the earliest that any EB5 investor in any project was eligible for repayment. So if you were in a backlog or whatever, let's say it took you 7 years to get to that stage, that's how long it would take for you to get repaid or be eligible for repayment. In October 2023, USCIS all of a sudden posted on their website, we've reviewed the March 2022 Reform and Integrity Act. Now we think that our interpretation of the sustainment period is you just have to be invested for a minimum of 2 years. And as long as the jobs are created, then you're eligible for repayment. I'm sure you've spoken to a lot of projects. You've done a lot of due diligence on all of these projects. No one's really ready to repay in 2 years, right?
Nobody
because
is. Yes.
development itself takes at least 2 years. And so there was a lawsuit aimed at basically stopping USCIS from simply posting on their website and that becoming law.
Okay.
We don't believe that USCIS can all of a sudden post something on their website and that becomes law. What if tomorrow they decided to post on their website, actually the investment amount is 1 million?
Correct.
There'd be a massive uproar.
Absolutely.
So then there's this lawsuit against USCIS. And while we're still waiting for the outcome of this lawsuit, we believe it will come out probably in one of 3 ways. Either a judge is going to say, okay, this interpretation is correct. Minimum 2 years, jobs creation, you're eligible for repayment. And don't forget, eligibility just means you're eligible. The project still has to be ready to repay you.
Correct.
Or they may change it to a minimum of 5 years. And it's the same rule, like 5-year investment, as long as jobs are created, then you're eligible for repayment. And the key to those 2 things is that it's no longer tied to your immigration timeline. Even if you haven't received or got to the 829 stage, you can still be eligible for repayment before that. Or the judge may say, actually, USCIS, you have to go through the proper rulemaking process. Until you do that, we're going to revert back to the previous rule where the sustainment period is your 2-year conditional residency period. So long story short, we don't know how this is going to come out, but I believe it will be one of these 3 outcomes.
So there are chances that it might actually get extended to 5 years. In that case, if you're looking at a timeline of getting your money back in 7 years, it might go up to 12.
I mean, getting your money back in 12, again, it really depends on whether it's tied to your immigration process. As long as it's not tied to your immigration process, then it just adds a lot more predictability to the overall repayment. Because then if a project says we're going to repay you in 5 years, there's a reasonable expectation that you'll get repaid in 5 years. It's only when it's tied to your immigration timeline is when projects have to build in their extensions because they have to comply with immigration. Because if it's tied to your immigration timeline and you're repaid early, then great, you've got your money back, but then you stand to lose your immigration benefits.
Got it. So what is it for the investors who have invested pre-RIA? Where do they stand if this goes ahead?
So the pre-RIA investors, unfortunately, they're stuck with the pre-RIA rule. So they have to wait until they file their 829, and only then are they eligible for repayment. It's the post-RIA investors. And, there's also some talk out there that hopefully there's grandfathering that's put into the language. So that means that if someone invested post-RIA, but before the judge rules on this, then they could potentially be locked into that 2-year investment period.
Yeah.
And again, it's not tied to your immigration timeline.
So what is it, that one thing that post-RIA, given now if investors are looking at investing in EB5, what is it one thing that they need to look at with respect to the whole lawsuit coming into picture? What should they be careful about?
I actually tell them that, look, the lawsuit is outside your control. It's outside my control. Now it's with a judge. So you're not going into, I think you go into EB5 understanding, or at least making peace with the fact that, look, this investment could get pushed out to 5 years. It could get pushed out to 6 years. As long as you're with the right team, with the right consultants, the right attorney, and the right project, and at least you have peace of mind that, okay, at least if my money is locked in for 5 years or 6 years, at least it's with the right people. So it's not a matter of if I'm going to get it back, it's just a matter of when.
Yeah. It's about trust.
A lot of
think.
trust.
A
And I
lot
think
of
it's
trust.
proper due diligence and it's a lot of trust. And, I tell my clients is you don't pursue a project based on the repayment terms. Just because someone promises you 2 years, that's not why you go into a project. You go into a project for various other reasons.
So, day in and day out, when I speak to investors, there's one major thing that we discuss about child aging out. And let's say if an investor is with you and he has a 19-year-old, what is it that you would advise with respect to EB5 for them?
Child immigration, EB5, is what I call a live event. So that means my advice is constantly evolving based on what's going on today with USCIS, with maybe the current backlog, the amount of people that have filed. So my advice maybe 2 years ago is different than what it is today. And I think someone who's doing EB5 post RAA, if you were to do EB5 2 years ago with an 18 or 19-year-old, you'd be fine because the age is locked in as soon as you apply for that I-526E, and it unlocks when that I-526E is approved, but you lock the age back in when a visa is issued. And a visa can only be issued if the visa fee bill is issued, but that can only be issued if a visa is available.
Understood.
Now, someone applying today with a 19-year-old, I think you have to understand the risks of age out. Because while the age is locked in when you file the I-526E, let's assume that it takes 12 months for that I-526E to be approved. So 12 months from now, when that I-526E is approved, the age will start to unlock. At that time, we have to see if visas are available. Now, as you know, demand for EB5 over the last couple of years has been high.
Yeah.
And at some point, we are looking at a backlog, in all
Yes.
honesty. There is going to be retrogression. Exactly when that will happen, no one knows. But if it happens next summer and someone has just applied today, then you could be looking at a potentially maybe 1 or 2 year backlog, maybe a little bit longer, and that 19-year-old may age out.
Understood. So, long term short, this is what entails with respect to CSPA.
Exactly. And so at the same time, this is for applicants who are outside the US. Anyone who's inside the US, you can file your EB5 petition right now concurrently with the adjustment of status, and that locks in your kid. So even an 18 or 19-year-old is locked in now because you're filing the 485 at the same time as the I-526E when a visa is available. So that child is actually fine. So I have no problem filing for a 19-year-old if they're inside the US. If it's outside the US, it's incumbent upon me to at least tell the parents that these are the potential risks. And then, maybe there are other ways to go around it. Maybe you put the application in the child's name if you only have one child. If you have two children, obviously that becomes a little bit more difficult because no parent wants to pick between two kids.
So, in your experience, where do you think parents actually get stuck in this whole process of aging out?
I think it's really if they have multiple children. That's the biggest thing. I think, I have many clients, if they have an 18-year-old and a 12-year-old, they don't really mind putting it in the 18-year-old's name because then you avoid any sort of risk of child age out because the 12-year-old is still young. They got plenty of time to go. I think it's when you kind of have, maybe two 18-year-olds or an 18-year-old and a 17-year-old, that's when it gets a little bit dicey, it's tricky. And legally, I tell them that if you have a priority of one child over the other, then you put it in that child's name. If you want to include this as a family petition, then there is that potential risk of age out. And you have to understand what those risks are, and you make a call based on that. As long as there are no surprises. And that's always my goal, is to make sure, advise absolutely everything and anything so that there are no potential surprises.
Yeah, I mean, that one thing I have to give it to you with respect to making anybody understand, like, let's say potential, and we've been on multiple calls with respect to making an investor understand what exactly that entails with respect to the pros and cons. I mean, you're crystal clear with it. And my investors have actually valued that.
Yeah,
and very happy with going ahead.
Exactly, because no program out there is perfect. And there's always certain things that happen, and that's with any immigration program in anywhere in the world. And EB5 is no different. And so I do tell my clients that, look, if you're going to do this, you have to make peace with certain things. The number one thing I say is processing times. That's something, again, no one sitting in this room has any control over processing times.
True.
That's purely the US government. So again, this comes back to, as long as you pick the right team for you, that's securing your capital and securing your green card, then you're going to be fine. But you do have to exercise a lot of patience going through this process.
Got it. So some investors actually wait for more than a couple of years for their I-526E approvals. So what are the causes for this? Like, what are the 2-3 things that you can point it out that can cause this delay?
So I think just to even back up a little bit is pre-RAA, pre-March 2022, I-526Es were taking absolutely forever. I mean, we were seeing cases go on for 4, 5, 6 years. And while we obviously have our own issues with USCIS, I do have to say that since March 2022, processing times for I-526Es have, they've gotten better dramatically.
Yeah.
We're seeing approvals in less than 12 months. We're seeing approvals in definitely less than 2 years for a majority of cases, which is hands down much better than it's ever been before.
This is for people already living in the US or outside?
Inside the US and outside the US. I recently had a client from Qatar, Indian born in Qatar, filed from outside the US, I-526E approval, went through the interview, got the immigrant visa in 14 months.
That's quick.
So you are still seeing, that's a massive improvement to what it used to be. At the same time, that doesn't mean that the government doesn't take an unreasonable amount of time.
Yeah.
And we still see that happening all the time as well. And so reasons for delays, a lot of it has to do, I think, with just the workload at the government level. I think you're seeing layoffs at the government level. USCIS, there have been layoffs. At the IPO, there have been layoffs. They brought in new people, new economists to review cases. So a lot of the times what we're doing with these EB5 cases, re-educating the government on what EB5 is, what are the true regulations, what are the requirements. And this can add slight delays.
Yeah.
But, there are also ways to combat delays. I mean, my team, we send regular inquiries to the government. Sometimes we get the senators involved to write an inquiries to the government. And then we also have writs of mandamus.
Yes, I was just coming to that. Because WOM is something people talk about a lot, but don't really understand what exactly this entails. So would you be able to break it down for us? What exactly is writ of mandamus and who is eligible for it?
Right. So a mandamus is a lawsuit. It's a lawsuit that's filed in federal court, not an application that's made with USCIS like a premium processing. This is a full-on federal lawsuit that's filed in federal court, but it's a tool that's used specifically for immigration cases, which basically is a complaint to a judge that says, look, my case has been pending for X amount of time. This case should have been adjudicated within X amount of time. The USCIS has taken, quote unquote, an unreasonable amount of time to process this case. And as long as you can show exactly the statistics behind it and the clear arguments behind it, then this complaint will essentially be accepted. Now, the process by doing it, the reason why people do it is because it adds a lot more predictability to your timeline. So for example, if I believe that a case was supposed to be adjudicated in 12 months and the client's case has been pending for 16 or 18 months, then I might recommend this writ of mandamus. We file this complaint in federal court, and then the government must answer within 60 days. We have to get an update from the government within 60 days. And usually they come back with some sort of update, either an RFE, or they approve the case, or the US Attorney's Office tells us, look, we're investigating this and we need some extra time. But again, everything is now according to a very specific timetable. Now, the good news, the good thing about the WOM, it's a really good tool for this, because it does mean we can start to get those adjudications within 60, 90, or 120 days. At the same time, because it's become a popular tool, people often want to get overly aggressive. And what I tell them is that this is not a premium processing application. That's not what this is. This is a federal lawsuit, and we have to take into account so many factors. Namely, in today's world, what does the political landscape look like? Where are we filing this case? How are judges in that state reacting to these types of cases? How's USCIS reacting? What are the statistics behind the amount of applications they've received and how long these are taking? We have to take all of this into account when deciding whether to file a writ of mandamus or a WOM. And it's the same thing that I said earlier. My advice on this last year is different than what I advise today based on these factors, and it will be different maybe 6 months from now as well.
Correct. But you must also be receiving a lot of interest from the clientele that you already have, saying that if it crosses more than 6 months, they might be pressurizing you with respect to go ahead and file a WOM. In that particular scenario, what is the best way to move forward? Because I do get a lot of clients saying that I think it's the right time for me to tell my attorney, but they also need to understand you cannot tell your attorney. You have hired an attorney for that reason. Yeah. And you need to trust them.
Yeah, I think, and it just comes down to, again, counseling. I mean, at the end of the day, that's what we are. We're counselors, right? So we advise them, we sort of walk them through the process. I walk them through my thought process that, okay, your case has been pending for 6 months. You've obviously just seen your best friend get his application approved in 6 months. So now you want to take your steps to getting it approved. And so I walk them through my process and I explain to them, again, the pros and cons. That if we file too early, these are the potential outcomes. Or if we wait 2 or 3 months, then here are the potential outcomes. Now you decide what you want to do, understanding this.
Got it. I was going to ask you what are the usual outcomes, but you have already covered that for me. So what is the biggest fear? Does filing cause a backlash or make things worse?
It doesn't. And that's the good thing about the actual WOM. I mean, you know what? We filed a lot. I would say, this really 2024, 2025, we filed a lot of I-526E and I-45 WOMs. And we do group filings as well. We filed...
Sorry to cut you off, but is it efficient with respect to costing? If
that's really what it is, yeah. It really is just efficient costing. It just brings down the legal fees. But we filed group mandamuses for 18 investors or plaintiffs at once, and we've done this consistently over a few months. In terms of what was the question again?
So with respect to mandamus, do you think there is a lot of backlash or does it work?
Okay. Yeah. We're not seeing the backlash, which is good. At the worst case scenario, if the lawsuit is dismissed, then your underlying petition would continue to move forward as it normally was. A lot of people are afraid of RFEs and things like that in EB-5. And, being a practitioner, and I've done this, for other immigration visas as well, the good thing about EB-5 is it's really just factual. There's not a whole lot of legal interpretation because it always just comes down to your I-526E is based on source of funds. More likely than not, you're going with a project that's already been approved or is about to receive approval. And then it just comes down to your source of funds. So if they have any questions about the source of funds, it's purely just factual. What is this bank statement? What is this transaction? And things like that. So sometimes you're probably going to get an RFE anyways. And so a WOM kind of just helps speed that process along, and you respond to the RFE, it goes right back in front of the officer anyways, and then it eventually gets approved. But, an RFE is probably like the worst case scenario.
Yeah. But also what happens is, given the current situation, the number of EB-5 filings have gone up, but also the patience level with respect to investors has gone tremendously down because of WOM. And it's crazy. Like, it's been 6 months and people want to file for a WOM. In those particular cases, do you really think once, if anybody passes around let's say stipulated timeline of around 8 to 9 months, and if they file a WOM, the chances are higher that their approval will be much faster compared to the traditional route?
It's a little bit hard to generalize because I have filed WOMs at the 6-month mark and the 7th-month mark. But, I'm also taking into account when did the project's 956F approval come in? And then how long since that approval has this I-526E been pending? Because if it's been a decent amount of time, then I'm a little bit more bullish and I want to file that WOM. If it hasn't, that's when I advise, well, let's wait a little bit because guess what? Your I-526E approval might just be coming around the corner. Why spend I would love to make legal fees. That's what we do. But at the same time, I don't want to waste my clients' resources. So I tell them, like, look, wait a couple of months. If it comes in, then great. You've just saved yourself a few $1,000s. If it doesn't come in, then we can still pursue the WOM too.
That's right. So there's a sweet spot for it.
There's a sweet spot. There's always a sweet spot. But again, it's a live situation, so that sweet spot's constantly changing.
Yeah. So for Indian and Middle Eastern families, the source of funds can get really complicated because there's a lot of gifts and ancestral properties involved. So what are the most common SOF that you have seen with respect to Indian and Middle Eastern angle?
It always comes down to, I think, just like you said, it's a lot of selling of ancestral property. And I think it also depends on different regions.
Yeah.
I think if we go to Gujarat and Punjab, you're talking about selling a lot of land, and whatever money you take from that, that's what you use for EB5. I think when you go to Bombay, it's a lot more of your brokerage accounts.
Mutual funds,
stocks, and all of that. And we see a lot of that come out there where they've just traditionally over the last decade have just invested. And now they're drawing or liquidating those investments and using that for EB5. Yeah. And I think when you go down south into Bangalore and Hyderabad, into your tech cities, you're seeing a combination of actually all three.
Yes.
You're seeing your income from your tech jobs. You're seeing a lot of ancestral land, and you're seeing them invest into
actually South India is a mix.
South India is like the biggest mixed bag, I would say. And then when you come to the Middle East, a lot of it's business income. If you see that they have a lot of corporations or companies that are doing so well, and they're able to draw on those profits and use that for EB5. So I would say those are the common sort of source of funds we see. How difficult source of funds gets really just depends on the documentation. And I think, one of the biggest things is the number one question I always get asked is, well, how far back do I need to go? And I always say to them, well, I don't know.
Yeah.
I won't know until I see your documents.
But that's the timeline?
So it's like 7 years. Exactly. So, even right now, USCIS, they ask for tax returns and financial documents for the last 7 years. So even they understand that bank records don't keep records for longer than 7 years. So if someone sold an ancestral property, but they acquired this property, let's say 20 years ago, we're not expecting them to furnish those documents. But we do, we follow that up with other secondary evidence like affidavits and declarations to explain what was going on in that moment in time. What were the source of funds used? How did this person acquire that property in that moment in time? Or what were the funds used to invest in the brokerage account at that time? So there are other ways to still tell the entire story, because that's what's important.
Got it. With these source of fund, do you think, does it derail the process of EB5 for them? Because there's a lot much structuring and a lot more process that you will have to do it in case of, let's say, example, if it's a gift, right? Yeah. There's a lot more documentation involved from the person who's giving you the gift. And then it coming to the primary applicant's SOF, the time just increases for them if there is an angle of this.
Yes and no. It just depends. I don't think it necessarily derails the process. Rarely have we ever, and I've been doing this for 10 years now, and we filed a few thousand EB5 petitions. So rarely have we ever said we cannot move forward with this case because of source of funds. So yes, some source of funds take longer because it depends on the number of sources, the quality of documents, and how responsive a client is. But, it rarely would we ever say that this completely derails our application. I mean, the number one thing I do say is someone who's taken a gift from a friend or family member, just make sure that they're okay disclosing their financial documents, because we have run into those issues before.
Okay. So what's one thing that you would advise for an applicant who has a messy source of fund? Usually, rather, I would rephrase it. What is the one strategy that you go to for a messy source of fund?
One strategy I go to is we sort of just break it. We kind of go back to basics. So, everyone has the funds. It's just how well can you document the $800,000 plus administrative fee. So we kind of ask the questions, okay, if you had to, we ask a client, if you have $800,000, where is it sitting right now? And walk me through how exactly it got there. And we sort of follow that thread, especially when there are multiple avenues that this money could have come in. Of course, if you're disclosing bank statements and you have a lot of transactions in those, we do have to explain those. But that's what it comes down to. As long as the client is willing to work with us and is patient with us, we can be very frustrating in our source of funds process. Even the messiest of cases, we do resolve them.
But I think I would like to say it in a way wherein you're actually safeguarding them from a rejection. So the more questions you ask before you file, the better for them.
Yeah, always. I mean, I think, especially today, everyone wants everything done yesterday. Unfortunately, that's not how EB5 or any immigration program works, especially source of funds, and especially if it's coming from outside the US. There is a process to it, and we follow a very meticulous process where we go through all the documentation and verify everything first. And only once we're confident of this getting approved, only then do we advise that they even start liquidating those funds and transferring those funds. And so, that process can still take, up to 4 weeks.
Understood. So do you have a percentage of clientele that come to you before going ahead with EB5? They actually want to understand if their particular source of funds even is eligible for EB5.
I would say almost everyone, almost every single one of my consult that I take on, even it's kind of the number one thing I ask them is where are your funds coming from? And usually within a conversation, you can tell. If I have my H1B clients and they're saying, well, I'm just using my employee stocks and my W2 income, and I can provide my tax returns, W2 income statements, bank statements, I'm like, okay, you're going to be fine. It's just a matter of us, connecting all the dots. Someone outside the US, if they're explaining to me, well, it's selling land or it's in my brokerage accounts and this is how long I've been investing, then I often ask them, well, let's also get your CA involved. I want to have a complete understanding of your financial history. And only once I've reviewed at least an initial set of documents, then I can at least give you the green light to start moving forward with EB5.
Understood. Got it. So I think this segment is really personal favorite for me because recently I've been speaking to a lot of people wherein there is a loan angle from a regional center. Okay. So have you seen people getting I-526C approvals, investors getting I-526C approvals with a loan angle in picture?
And it comes with a caveat that as long as these loans are structured correctly, then yes, we have seen it.
So obviously it's not like the regional center is directly providing a loan. There is always a third party angle to it because they are not liable to provide it by EB5 laws, right?
I think a lot of people actually disagree with us on the loan angle. And, my partner and I, we've kind of been a little bit more aggressive on the loan angle. Because we have case law that backs up loans. So first, Zhang versus USA, which was an absolute landmark case for EB5, basically told USCIS actually unsecured loans are allowed. So first and foremost, as a very baseline, unsecured loans are allowed for EB5 purposes. And so we use that as a basis that, okay, well now, as long as you can document where this loan comes from with a proper source of funds documents, as long as it's a legitimate loan that has a proper underwriting process, then we don't see a reason why this loan would not be allowed.
Okay. But there's always a caveat to it. Okay. So let's say if I'm an investor who is looking, let's say I have a liquidity of 400K. Okay. 400K loan I'm taking. Okay. There are multiple regional centers out there. Situation one, there's a regional center who's giving me 400K loan and they have told me that there's a timeline of 3 years. There's a X number of interest involved in it. By the end of the third year, you have to ensure that you are paying the principal of 400K, that the loan that they're providing for. Okay, one. Situation two, there is a regional center who is giving you the loan of 400K, but telling you, do not pay that 400K. Rather, I will adjust it with the 400K that you put in the front.
Option two, I think, could get you into trouble if it's not structured correctly. Option one would be your more traditional loan. And that's what we sort of look for, where you have the interest payments. And don't forget, even when you're making these interest payments, they should be fully documented. So, we make sure that when one of our clients is taking one of these loans and they're making the interest payments, these are fully documented. It comes from a verifiable source. And then when they make that eventual capital payment for the loan, that also comes from a verifiable source.
Okay. Do you see I-8 to 9 approvals in situation 2, where you're paying in 400K and paying the interest for the duration of time that you're taking the loan for, but not with the principal?
Time will tell. This whole loan idea recently sort of came on board over the last, like, I would say, year or two. And so people who have been using it, or people who have even gone through option 2, we're not going to know until they get to the 829 stage.
So, what are the 3 things that USCIS looks at with a loan angle and structure to approve an I-829?
Again, we won't know because none of these people who have taken loans, they might have gone I-526E approvals, and they probably just recently entered their conditional residency period. So we're not going to know until they reach the 829 stage. At the same time, USCIS can look at your source of funds at any time, even post 829 filing. We're not typically really seeing that though. So again, time will tell whether they reopen cases at the end of the 829, but I don't expect them to.
Got it. But isn't the program designed in a way wherein even if you're taking the 400K loan, you have to ensure that you're repaying that back? Because if you don't do that, then it beats the whole purpose of that program.
Correct. So you obviously have to show that you invested $800,000, and if you are taking a loan, that you've not just have repaid the loan, but you have the ability to repay a loan. And that's where I can't speak for every loan that's out there, but at least the ones that we review and that we advise our clients on taking on, we make sure that there's a proper underwriting process from that lender who's checking the credit worthiness of who they're lending to make sure that this person who's borrowing has the ability to repay that loan. And then that's what we also document in our source of funds.
Got it. Okay. So you've worked with numerous investors involved in different projects where the outcomes varied. That's not just one legal mess, but it's an emotional one too. But for a lot of people, actually. So, what are the red flags that one investor should see before choosing a particular project?
Yeah, I think that's a really good question. So every so often, actually more often than not, an investor or a client will always ask me, Neeral, I want to go to EB5. I don't know where to start with projects. What should I be looking for in a project? And so, there are certain things that I tell them to look out for, which is what we look out for. We work with many regional centers and many projects, but I wouldn't say we work with everyone out there. We've done this for long enough that our clients have gotten their permanent green card and gotten their money back. And so we have a fair idea of what to look out for in a project that's going to protect these two interests or these two risks that every investor takes on, the financial risk and the immigration risk. So the first thing I always ask them to do is, forget about EB5 for a second. Look at this asset that you're investing in and look at the developer who's developing this asset. Make sure that this is someone who's done this before, developed this type of asset before, and they've done it successfully. Obviously, past success doesn't guarantee future success.
Absolutely.
But at least, compared to someone who's doing this for the first time or someone who's done this many, many times before and it's almost cookie cutter for them, that gives you a sense of confidence in the developer as well. And then we also want to make sure that these projects are fully financed. And that's something that USCIS looks for. We file many 956F applications for projects. We preparing this, we don't file 956F until we're absolutely positive that this project has secured all of its financing. What that means is if a project has the capacity to take on 100 investors and they only take on one investor, they should still have sufficient funding as if they never raised funds from any more investors ever again.
Correct.
Because that means that project, we want to make sure this project isn't depending on EB5 money.
Yeah.
And that's what USCIS also cares for as well. They want to make sure that the investors are protected. Then we also like, when we file a 956F as well, and I tell investors, make sure the project's already under construction. The biggest delays in construction, and I probably say this anywhere in the world, not just the US, is during the permitting phase.
Exactly.
To get permit certificates, the permissions to actually start building, all the contracts in place, that itself, there's a lot of delays involved there. Once a project's already started construction, that gives you confidence that, okay, you can actually see a tangible asset that's being built. So that means money is going into this, the job creation is already happening, and that again gives you some more confidence that, okay, things are moving along. And then you have other things in place like, sometimes I'll have developer completion guarantees where the developer is contractually obligated to complete this project as per the business plan. And if there are any sort of cost overruns, then the developer is responsible for that. We want to make sure the developers put in equity into a project. If you're an EB5 investor and you look at a project and you see, okay, there's a bank loan and then the rest of it's just EB5 money, that's a scary place to be in.
Exactly.
That means you want
How
the
will you get
developer,
repaid?
exactly, how are you going to be repaid? So you want to make sure that the developer itself is also invested and stands to lose something if they don't perform as they're supposed to. And then right now the world's in an interesting place where you don't know a whole lot of with tariffs and all sorts of things, right? So I also want to make sure that my clients ask the regional center or the project, well, how have you done during other trying times? How did what did you do during the 2008 crash? What were you doing during COVID? How are tariffs impacting these projects? That way you have a complete understanding that if they were able to go through those times successfully, they know clearly what they're doing.
True. It's only human that even if the projects do not perform, how a particular regional center is actually taking care of those investors tells you a lot about it, I feel. Because even if there is any kind of failures, you also need to see how were they taken care of before investing. At least it shows you the angle, let's say, if things do not go as planned.
Yeah, exactly. I mean, I think there are plenty of regional centers out there who, in my opinion, are sort of investor focused. And, they really do put their investors first. And that's kind of like what we like to see, because at the end of this, in the EB5 ecosystem, I think a lot of clients kind of forget this. We all need to work together. All of our interests are aligned. Whether it's you on the consulting side, whether it's us on the immigration side, and then obviously the regional center on the project side. Everyone here needs to work together and ensure success for everyone to go through this.
Correct. So, what if someone finds themselves in a bad project? What should they do?
First,
Immediately, rather.
yeah, immediately is really just to get in touch with your attorney,
Yeah.
get in touch with your regional center, and find out what the actual risk and exposure is. Because, at the end of this is still development. These are still real estate development or manufacturing development, whatever it is, right? And everything can always stand to fail. Obviously, you look at the criteria that I just talked about, and you look at those different factors, and that minimizes your risk. It can never minimize your risk to absolute zero. There's no such thing. But it does minimize your risk considerably. Doesn't mean anything can't go wrong. It just depends at what point something goes wrong. And so that's why I say that, if you go into a project that's fully funded and already under construction, let's say it's more than 50-60% already constructed, jobs are already created, chance of that project failing, of course, are very low. But if for whatever reason something does fail, then at least 60% of jobs are already created. So you could still potentially go through the immigration process and get your green card, and there's still a way out that way. But it just obviously depends what's going on with the project. Is it truly a project failure, or is it a project delay? Because a project delay, again, isn't the end of the world.
Understood. So, this is a situation based question. There's an investor who's invested in a project A. Okay. I-956F is not approved. It was applied, receipt has been given, but there are two RFEs that has been raised. At what situation? And he's spoken to the regional center, all of it, and he's gotten an information saying that yes, it is going to get approved, but we don't know when it is going to happen. In that case, and if there is a situation of an H1B getting expired of the primary applicant, okay, so what is it? Are there chances for the investor to move the project? And if so, what are the things that they should be taking care of?
So assuming obviously they've already filed their EB5 petition, they filed the adjustment of status, and the H1B is expiring, yeah, there's always a possibility of moving projects. Again, you'd have to speak to the project, see what the voluntary withdrawals are. Some projects still, once you've invested, you're locked in. Especially if the funds have already been deployed to the project, then you are locked in for the long term. Assuming maybe the funds are still just sitting in escrow and nothing's happened and you withdraw, then yes, you can potentially get your money back and invest into project B. Of course, if the H1B is expiring, then we do have the immigration side of things to strategize. If they're looking to file a new adjustment of status, we want to discuss maybe, and they've used their EAD from the previous application, we may want to talk about how do we get them back onto a valid non-immigrant visa like the H-1B before it expires, and then potentially filing a new adjustment of status application with the new project. All that to say is that there's a way. It just obviously has to be done carefully, but there is a way.
That is the way if you have the right ally by you, that's your immigration attorney, I feel.
Yeah, that would be the first person I would go to, is go seek your consultants, go seek your immigration attorney, explain exactly what you're trying to do, and I'm sure they would advise you appropriately.
Correct. And I feel with these situations coming into picture, you need to have 100% trust. Don't doubt your immigration attorney or your consultant. And if you do that, then don't go ahead with them.
Yeah, exactly. That's the other thing. Make sure you also do your due diligence on your immigration attorney. Make sure that this is someone who's experienced in handling these types of cases before, complicated cases, because I think a lot of investors, and these are complaints that we see in the industry, is they believe that their relationship with their attorney is transactional, that they're only interested once we file the EB-5 petition and then we never hear from them again. And I don't think that should be the case. You want to be with an attorney that's going to be with you for the next 5 to 6 years, and they're just as invested in year 4 as they were in year 1.
Correct. I always keep telling my clients, this is not a transactional relationship. It's an emotional and it's a family bound relationship that you're going to look at for the next 7 years at least minimum, until you get your repayment back.
Yeah, I mean, look, I'm an immigrant myself. I mean, I was born and raised in the UK. My family moved from Gujarat to the UK to the US, and now they got UK citizenship, US green cards, and then US citizenship. So they've done the whole thing, the holy trifecta. And so immigration is also just very important to us. Our whole firm is made up of actually a lot of immigrants. And so, we kind of, yes, we haven't got here through EB-5, we got here through other ways, but we do at the same time understand what it means to, pursue a green card, be on a green card, the issues that you may have when it comes to traveling in and out of the country with employment and things like that. So I think it's important that you also reach out to a team that understands these complexities and can walk you through it.
You've been there, done that, and exactly relate well to the
Exactly.
investors.
Yeah.
So I've noticed many investors get drawn into flashy returns or timelines, but they don't ask the right questions about immigration and about the financial health. So what does immigration viability actually means in your legal opinion?
In my opinion, immigration, you want to look at two things for EB-5 is how well protected is my green card? How well protected is my capital investment? This is not an investment program. It's an immigration program that requires an investment. And it's important to make that very nuanced distinction, because you're not doing this to make money.
True.
You are not looking for high returns. High returns just simply come with higher risk. And that's with anything in the world.
Yeah.
If someone's offering you high returns, you've got to be asking why, right? And what we look for are vanilla projects.
Yeah.
Essentially boring projects. We want them to simply take care of you, take care of your capital investment, and take care of your green card. If you're looking to make money, you don't do EB-5.
Exactly.
You find other private investments and you go into those. EB-5 is the true interest you're getting is long-term stability and security through permanent residency and a path to citizenship.
That's right. But when equity investments come into picture, people usually get drawn towards those flashy returns. And then they try to jeopardize their green card also, plus not getting the capital back. And it's a very chaotic situation in those cases. So out of your practice in the last decade, how many cases have you seen debt versus equity?
I would say majority are debt. Majority are debt. Of course, we do see some equity models out there. And to be honest, they're not all absolutely terrible. But again, equity models do come with higher risk, right? And so again, this comes back to when I have a consultation with a client, I always ask them, what's your priority? Is your priority the green card, or is your priority your, making a return on your investment? If that's the case, then by all means, you do it, because at least you understand what your risks are. But if your priority is immigration and simply to protect your capital at an absolute baseline, then you go into this sort of probably more traditional debt model.
Got it. And how can an investor access a project that truly supports their EB-5 journey through the I-829 approval?
This comes down to your due diligence on the projects. And I think it's also relying on consultants like yourself, right? Because I mean, you've also built these relationships with these regional centers. If they have a long track record of doing multiple projects and seeing their previous projects through to the 829, that gives you a lot of confidence that, they're here to stay through the 829. I think, I appreciate it when projects give regular updates to clients, quarterly updates to clients about job creation, how well the project's doing, and things like that. There are a number of regional centers that do a really, really good job of that. Also important to know that, every single regional centers also has to prepare and file an audit report every single year with USCIS. So that means every single year, each regional center has to report to the government an update on each project that they sponsor. They also have to update them on job creation, how much EB5 funds they've spent, how many EB5 funds they've raised, non-EB5 funds they've raised. And so everything has to be updated every single year. Post RAA, we're actually seeing a lot more site visits by USCIS, checking the books on projects on their site. So this is keeping everyone a little bit more on their toes and more honest, and it truly is for the investors' benefits, but that gives you an idea that they're going to be here through the 829 stage.
Correct. Because there are multiple regional centers who also have virtual visits. They actually do that because it also shows the transparency of a regional center, right? Because even if physically it's not possible for the investor to be there because either they are doing filing from outside of US, it's only about the transparency. That makes sense, right?
Yeah, exactly. And I think the good regional centers are fully transparent. They'll tell you the good and the bad. No, like I said, no one is absolutely perfect. There is a certain level of risk that's associated with this, and there is a leap of faith that every investor takes on. But just because you take on risk does not mean it's a risky program or a risky project. I think once you speak to the regional centers, you get a sense of how transparent they are, and that gives you confidence in going through with them.
So decks often mention the repayment or a completion guarantee. Completion, I understand. But what's the difference in reality if I have to look at it? Completion guarantee, repayment guarantee.
Well, I think the first thing to understand is your funds back to the investor cannot be guaranteed. That's the number one thing. No EB5 project can ever say we guarantee you repayment because that is in immigration law does not allow that. So, a lot of investors come to me and they say, I don't trust this regional center because they can't guarantee repayment. Just so everyone knows, they're not allowed to guarantee repayment by immigration law. Otherwise, the project's shut down. But, we have seen obviously completion guarantees that, like I said earlier, gives you a sense of that at least gives you confidence that this project's going to be built. There are always cost overruns. There are always delays in any real estate development. And so that completion guarantee at least makes the developer contractually obligated to see this through. And so then once that's obviously if it's built, then you have a sense that, okay, then I'm going to be repaid. We see that the repayment of the loan from the JCE to the NCE can sometimes be backed by a developer's sort of assets and things like that.
Yeah.
And we see that happen.
Collaterals.
But again, that's also going to be structured very carefully so as it's not a guaranteed repayment back to the investor.
Got it. So in short, if any regional center is promising you a repayment guarantee, run faster than you could in a marathon.
Correct. Exactly. No one can ever guarantee you your funds back.
Understood. Are these guarantees legally enforceable and should investors trust them from an immigration or a financial perspective?
Guarantees are enforceable. I mean, I think everything in EB5, it's not just overseen by USCIS, but it's also overseen by the Securities and Exchange Commission, the SEC. All the PPMs, operating agreements, limited partnership agreements, all these agreements that you enter into are overseen by two very strict government agencies. And, we've seen them be enforceable in court before. When a regional center has failed and we need to step in to sort of save the investors from their, immigration status, we've worked with receivers on the SEC side to enforce these agreements against the regional center and to save the investors. So these are absolutely enforceable agreements that are being written down.
Understood. So that's one critical question, especially for students or working professionals already in the US. So if someone's applied for I-526C and is denied, what happens to his or her F1 or H1B status?
That's a really good question. So it depends. So let's just take the H1B, for example, first. So I'm an H1B holder. I filed an EB5 petition along with my adjustment of status.
Okay.
My EB5 petition has been denied, but I've maintained my H1B. I never moved over to an EAD or the AP because I've been so happy with my employer, and I wanted to wait until I get my conditional green card before switching over. In that scenario, you still maintain your H1B, so you're still fine. It's as if nothing ever happened, and you could always file a new EB5 petition. Let's assume that I'm on an H1B and I've started using my EAD because I want to start my own business or want to work for someone else. If I've moved on from my H1B employer and my EB5 petition has been denied, then as long as you still have validity left on your H1B over the 6 years maximum, you still have time left, then you could still find an employer to sponsor you for a new H1B. You would leave the country and come back in as an H1B holder.
So for that to happen, let's say you have moved to an EAD and you still have a valid H1B. Okay. In between, if my FI260 gets denied, I have to exit the country and come back again for that H1B to come into structure. Is that so?
Exactly. You need to enter in as a non-immigrant because unless if you never left, let's say you never left on your EAD and you're still on your H1B, then it's fine. Then you're okay. But assuming that as soon as you got that EAD and that advance parole, you left the country and came in as a parolee, then in order to sort of activate the H1B, you'd have to leave and come back in again on H1B.
Okay. Understood. And in case of an F1?
In case of an F1, it's very similar. Technically, the F1 is only a single intent visa. So once you apply for the green card, which is the adjustment of status, you technically move off of the F1. But if you're still in school, your CVIS number will still be valid. Your I-20 would still be valid. You haven't really done anything to change your status, even though you technically have. It's very, very nuanced. So let's say you filed your EB5 concurrently while you're an F1 attending university, and then your EB5 petition was denied, but you never left the country during that entire time.
Okay.
Then you could still continue on your F1.
Understood.
If you left when you got your EAD and advance parole and you came back in as a parolee, and then your EB5 petition was denied, then you would need to leave the country, potentially get a new F1. Again, that can be difficult because you've kind of already shown your intent to apply for a green card.
Yeah.
So it gets a little tricky if you're an F1 student.
Understood. So is there any way to create a legal safety before things go wrong?
I think that goes back to some of our earlier comments, is picking the right team. If you have a good attorney, a good consultant, and you have a good regional center, you're not really looking at denial. I mean, that's one thing I always tell my clients is the way we operate is we're not filing your petition unless we're absolutely sure that we've crossed all the boxes to get this approved. Because then I'm fine with my F1 students moving over to an EAD. I'm fine with them traveling on their AP. I'm complete confidence because I know that we prepared this in such a way that we're not looking at a denial.
Understood. So this is one particular question which I get a lot from investors outside of US, okay? They've gone in B1 to US. There's a 60-day period, right? Sorry, 90-day period. 91st day, they can declare themselves as EB5 investor. But if an investor enters into the country on a non-immigrant visa, okay, then he shows his intent and files for an I-526C on the 91st day. What is the scrutiny by the USCIS in this case?
There's a lot of scrutiny. I think everyone needs to know that, especially a B1, B2 is for tourists or very, very preliminary business reasons. And it only has a 180-day period where you can stay in the country. But you have to come in strictly for tourist reasons. You can't come in to even go to school. You can't come in to work. You can only come in for those particular reasons. And it's a single intent visa, which means you cannot come in with the intent to apply for an immigrant visa. Now, someone who comes in and then waits 90 days and on the 91st day files an EB5 petition concurrently with the adjustment status, I think it's important to know that the government could always come back and RFE the 485 and they can say, well, show us that you came in for tourist reasons. So, we've had clients who have actually been in the country for tourism, and then it wasn't until like the 5th month they've discovered EB5 and they've, decided to pursue EB5. So we've always had the conversation and talked about it, but whether you can go through with it or not is a different story. And that's something that you need to discuss.
It's case by case.
It's always case by case.
Understood. So this year we've seen a huge wave on H1B, F1, L1, EB1A also, professionals who are turning to EB5. Many due to layoffs, visa lottery issues, and the current government situations, right? So in this case, what are the biggest legal and lifestyle options that EB5 can provide to these individuals?
So, there are 5 EB categories. There's the EB1, 2, 3, 4, and 5. EB standing for employment based. EB4, I've never even done an EB4 case, so I don't even really talk about it. But especially for, let's say, Indian-born nationals, the EB2 and EB3 categories have a 60, 70 plus year wait. So already you're going to outlive a green card on those visas. In the EB1 category, there's a backlog. And it's not a severe backlog. It's only a couple of years. But the EB1 categories require such high standards. For example, there's the extraordinary ability EB1A. And that is, you have to meet 3 out of 10 criteria. And usually it's someone that's published a lot of papers, journals, citing, maybe won an award, things like that. Someone really in the top 1% of their field and who's coming in to do something very similar. They qualify for the EB1A, but again, heightened requirements, higher standards. The EB1C is multinational managers or executives. You have to have a company outside the US.
Yeah.
You have a company inside the US. Those are the types of people that come in on that. So then the EB5 actually often becomes the easiest if you have the financial means to do it, because there's no language requirements, there's no education requirements, no years of experience requirements. As long as you have a clean criminal background and as long as you can document where your $800,000 comes from, you're going to get your EB5 visa. In terms of why we're seeing such, I would say since 2017 and 18, we've seen a lot of people, a lot of Indian nationals move over from F1, H1B, and they flipped over to EB5. And the reasons are quite logical. For the F1 students, and this is for any F1 students, forget about not even just Indians. This is any F1 student in America. You need an I-20 and enrollment into a school. Then if you want to take on internships during your school year, then you have to apply for an OPT EAD. That EAD specifically has to be tied, or then you have to be sponsored for employment, and that employment has to be specifically tied to your program of study. So there's not a whole lot of wiggle room to explore other areas. And then post-graduation, if you want to stay in the country, you can go get a master's degree. That's another 2-year F1, fine. But then post that, in order to stay in the country, you have to get an H1B. And the H1B, you have to go through a lottery system. There are 60, 80,000 visas available. Over 200,000 people apply. Chances of getting the lottery aren't great. And if you don't get picked in the lottery, then you have to return home. So then with EB5, it gives you that sense of security, stability, and it just opens up so many more opportunities for you. So our F1 students who have already been in the country and they filed for the EB5 petition and their adjustment status, now they no longer have to worry about sponsorship for internships. Once they graduate, they know they're going to have at least an EAD in hand. They don't have to worry about going through the H1B lottery. Some of them will even have a green card in hand. So they're just permanent residents. They can start their own business if they want to. They can basically do whatever they want to, almost like a US citizen.
Correct.
In the H1B side of things, I just told you the EB2 and EB3 can take 60, 70 years getting a green card.
And no tying up with an employer also, right? If you're
Exactly.
on an H1B, yeah.
You're tied to your employer. Once you're done with your 6-year H1B visa and you file for that I-140 under the EB2 or EB3 category, your H1B has to renew every single year.
Yeah.
Until you get a green card through your EB2 or EB3, which is 60, 70 years away.
Yeah.
So that means you're tied to your employer every single year and you have to go through this process.
And at the misery of a lottery.
Well, I mean, this is past the lottery, right? So once let's say you've gone through the lottery and you found an employer to sponsor you. Then,
no, I'm saying about with respect to every 6 years, they'll have to get it applied for it again, right? Via the whole lottery system.
Well, once you've applied for the I-140, there's no lottery system. Then you just keep applying for your H-1B extension every single year. And so, but still, you're kind of living in a world of uncertainty because what if your employer all of a sudden says, I don't want to extend your H1B anymore? And, we see mass layoffs in Silicon Valley in the last couple of years, right? And so once you're laid off, you have 60 days to find another job or you have to leave the country. And a lot of these H1B families, they've had kids who have now, turned into teenagers and they'll go to school. It's hard to pull them out and move back home to India or wherever else. So we've seen them flip over to EB5 because as soon as you file for that EB5 petition and the adjustment of status, that allows you to stay in the country.
And given the whole government situation right now, I mean, the number of calls I have attended since February, it's crazy.
Yeah.
Because employers are taking away their sponsorship or not. And even on a valid H1B, they do not want to continue it because the liability is too high for the employers, is what they say.
It's becoming expensive for employers. And then on the client side, if you're having to travel, right now, who knows if you're going to get a visa? To getting a H1B stamp, sometimes the appointments take too long. Sometimes they're getting denied. The reason why people are flipping over EB5 and then using the AP and EADs is because they no longer ever have to worry about that. Then you can travel in and out freely. You don't have to go for visa stamping. You can work for, now employers are more likely to hire you because you don't need sponsorship. You can start your own business. And guess what? Even if you don't have a job, you can still remain in the country.
So, are there any traps or any timing issues they should be cautious about?
My number one thing is, all of US immigration is based on supply and demand. There's only a limited number of visas available, and the demand for each one is constantly going up. That's why you see the 60 or 70-year wait in the EB2 and EB3 category, because Indians prior to 2017 were primarily using EB2 and EB3. And that's why you're now seeing a backlog in the EB1. EB5 is also the same. There's a limited number of visas available, and the demand for EB5 is only going up. Once demand exceeds supply, then they introduce what's called retrogression or visa backlog, which means if you just Google visa bulletin for a particular month, you'll see a chart. And if you go down to EB5, today you'll see that it's all current.
Yeah.
Which means that according to the chart, demand has not exceeded supply.
Yes. We were actually worried that India is going to go retrogress by March, April, every month. We were like, oh, India is going to retrogress.
I hold my breath every single month when that visa bulletin comes out.
Yeah. But right now, the anticipation is by the end of the year.
We're hearing end of the year, we're hearing next year. But again, the State Department can do whatever they want to. They can issue a cutoff date. We know for July, it's current.
Yeah.
So that's fine.
Let's take 1 month at a time.
1 month. And that's all we can do, because it's funny because a lot of clients will always ask me this, when will it retrogress? I'm like, if I had a crystal ball, I'd probably be doing something else. No one knows that answer because everyone only finds out the same time, which is about 3 weeks in advance.
Yeah.
So what I tell, again, this is something when I go through my consultations with clients is they always ask me, well, how long will this take? I'm like, we don't know the true answer to that question because we don't know what retrogression is going to look like. A, we don't know exactly when it's going to hit. And B, we don't know what that timeline is going to look like. And then C, even once that date is announced, we don't know how quickly or slowly the dates are going to progress each month.
Yeah.
That's just information that I don't even think the State Department who's in charge of this has. So we for sure don't have that information. So I do tell clients that if you're applying with EB5 right now, you're applying under an interesting time. I think if you're inside the US, you make peace with the fact that you may get caught up in retrogression and your green card may take a little bit longer than you anticipated. But as long as you file now, while the visa bulletin is current, then you're going to get that APEAD. And that APEAD, that Advanced Parole and Employment Authorization, gives you that unrestricted right to work and travel for that most likely it's going to be issued for 5 years, and it's always renewable. That's not subject to the visa at renewal time. So at least you can secure that. Anyone who's outside the US, it's unfortunate because you don't get these interim benefits of work and travel. At the same time, if you're asking me, this is still the quickest way to getting a green card.
I mean, given we are talking about the black hole of EB5 bulletin, there's a lot of conversation happening with Trump's gold card.
Right.
And with the new website coming into picture just yesterday. So, to rightly put it in my term, it would be a black hole because nobody knows the terms and conditions. Every day we hear it in the news saying that these many gold cards have been sold out, but to whom? And let's say if you're not taxable for a certain period of time, what is that time that we're looking at? And what is the income level that we're looking at? So, given the whole uncertainty about it, and people who were looking at EB5 also have come to a situation wherein they're like wait and watch. So, what is there a wait and watch scenario with respect to this?
I don't think there's a wait and watch scenario to this. I think if you're someone who has the financial means to do EB5 and you've otherwise made up the mind to do EB5, it's only in your benefit to do it sooner rather than later, regardless of the gold card. Because A, there is no framework properly for the gold card. And B, we don't believe that it's actually going to replace the EB5 program because it serves a complete different objective than the EB5 program. I do believe that there's a place for both the gold card and the EB5 program because they serve two different objectives. But one is not necessarily replacing the other. But right now, all you do have is an EB5 program, and that's written into law. So anyone who invests in EB5 today is locked into this program. And they have the assurance that through the grandfathering provision in the EB5 program, that if anything changes tomorrow, then they're protected against those changes.
Until 2027.
Until 2027. So the current law says that anyone who invests by September 30th, 2026 is going to be processed under this program. In 2027, if the amount goes up or timelines change, they will not be subject to those changes.
So one last thing, if anybody had to think about the whole wait and watch situation with respect to before investing in EB5, given the gold card is into picture, if he or she is filing before the 2027 of September, nothing to be worried about because none of the laws are going to be affected to them. But only thing that they have to look at is with respect to the project angle and the normal norms of EB5. Is that right?
Exactly. The gold card was announced in February. And since then, the most we've gotten is a waitlist website. There really is nothing to it right now. There is no regulation that's been announced. There's no form to process. There's no visa category for it. There's not even a tax code amendment. So there's really nothing else to it. That doesn't mean nothing will happen. Of course, at some point, I do believe we're closer to a gold card today than we ever were before, which is, again, completely fine. I think there is a place that I think eventually how this plays out is there was a separate place for a gold card and a separate place for EB5, because the EB5 program is for economic growth. It's for, bringing and job creation. So these senators and House members that we meet with in DC once a quarter as well, they're hugely supportive of EB5 because it brings so much development, so many dollars and job creations to their individual districts and to their constituents who vote them into Congress, that, it's a win-win. The gold card serves an entirely different process because that's to bring down the deficit. And that's more of a donation anyways. So they can coexist in different ways. If anyone who's waiting and watching on EB5 to see what happens with the gold card, I just think you're going to end up waiting and watching too long.
Correct. Got it. So Neeral, before we go, what is the one advice, if you had to be brutally honest to an EB5 investor, that you would give them that none of the other immigration attorney consultants or anybody would give them?
It's not always pretty.
Yeah.
I can't say that this is going to be easy. Yeah. I can't say that it's not going to be stressful because it's an immigration program. And I think with an immigration program that's tied to politics, it comes with its own inefficiencies. It can be stressful. But what I do say is that's, it's our job to take on that stress. You put your trust in experts, expert consultants, expert immigration attorneys, and expert projects, and they will get you through this. If the only thing you have to be worried about or stressed about is processing times, then everyone's doing their job correctly. You shouldn't be worried about, is my money coming back? You shouldn't be worried about if I'm going to get my green card. Those two things we can all take care of. It really comes down to processing times.
Yeah. Perfect. Thank you so much for giving your invaluable time. And I think I'm always in gratitude to you because there are a number of things to learn from you. And not only with your legal expertise, but also putting in the heart and the honesty to this conversation.
Absolutely. No, thank you so much for having me. This is great.
Much. To everyone listening, if this episode helped clarify something that you have been stressing about, please share it with a friend or leave us a review that what you might want to cover in the next episode. And also remember, when it comes to EB5, you deserve transparency, strategy, and someone in your corner. Until next time, stay informed, stay empowered, and always be there with a smile.